The chair now recognizes the gentlelady from Arizona. School for 5 minutes.
Thank you, Mr. Chairman, and I wish you the best in your future endeavors. My questions are from Chairman Glick, for Chairman Glick. Chairman Glick, I'm concerned that FERC is unfairly second-guessing final decisions that the commission made under the prior chairman. For example, FERC recently issued 5 notices of intent to prepare new environmental impact statements and projects for which FERC already determined that final environmental assessments were sufficient. So going forward, Chairman Glick, can the public and regulated industry rely on FERC to make final decisions and then stick with the decisions?
Thank you for the question, Ms. Lesko. I would disagree with the premise of the question. Actually, the FERC never did say that those previous environmental reviews were sufficient. Those were staff analyses, and they didn't make that determination either. Basically, we're doing what the courts are requiring us to do, and I want to use as examples. Over the last several years, the courts have repeatedly said FERC is not doing this right. We're not, and other agencies too. They're saying FERC and other agencies are not essentially reviewing pipelines sufficiently in terms of the environmental impacts. And what happens is we issue our orders in the past. The courts send it back to us. It takes several years to go back and do the additional reviews. And what all it does is cost extra money, and in many cases, it causes pipelines to cancel those projects. It's happened in the past. So what we're trying to do is follow what the law requires and what the courts are telling us. And so we're trying to do, if you look at the last several court cases, they're essentially saying we have to do an environmental impact statement to review the environmental impacts of these particular projects. And so we're doing so. In the long run, it's actually going to expedite the process, not slow it down.
Thank you for the answer. My next question is also for you. In Order 871, which was recently implemented this year, FERC changed well-settled practice and created new project risks. Order 871 significantly restricts what companies may do while requests for rehearing of FERC certificate orders are pending, which can delay a pipeline's access to the land necessary to conduct project surveys for environmental and cultural resource permits, land acquisition, and construction. The order also announces a presumptive stay on all future pipeline certificates pending rehearing proceedings, which is contrary to congressional direction in the National Gas Act. Further, the order is not clear about what a pipeline needs to prove to lift the stay. The order provides incentive for project opponents to seek rehearing to delay projects. We all know that building infrastructure projects has taken longer and longer in recent years. How much delay do you expect FERC's recent Order 871 to add to pipeline development timelines, considering that most of these projects already have multiple years to design, permit, and build?
So Order 871 essentially was a response to the courts, which essentially told the FERC that we weren't handling the pipeline siting process sufficiently in terms of ensuring that landowners have their day in court. And I want to quickly explain, under the Natural Gas Act, when you get a certificate of public convenience and necessity, you automatically, then the pipeline developer can automatically go to court and actually take land by eminent domain. Where those people, landowners and others that are challenging the commission's decision to issue the certificate, it takes a little while because of the way the Natural Gas Act is written to get to court and thus we challenge those particular decisions. So what 871 says is we're going to delay the effective date of the certificate to give those parties enough time to make their challenge at FERC and then go to court. And if the court then stays the commission's decision, that's one thing. If they don't, then they can go and move forward with taking land by eminent domain. But it's all about making sure that landowners have their day in court before land is taken by eminent domain.
How much time do you think that will add onto the already long time it takes to get permitting?
If any time, and I can't give you a specific answer, I think very little, in large part because the process, we limited under 871B, what the commission did is limited this time period to 90 days. So essentially, you have to wait 90 days or earlier if the commission acts on the rehearing proposal earlier before you can actually go to court and seek to take land by eminent domain. But that's early on in the process. It's not necessarily going to delay the development of the pipeline itself, because it takes a long time, even if you take the land, you have to get the other permits you need from state agencies and other federal agencies.
Thank you. I yield back.